Okay. All right, we'll get started. So as to the requests for admission of exhibits, the board has deliberated and is going to admit all exhibits except portions of Exhibit K. Exhibit K is a variety of emails. The first email in Exhibit K is from somebody named Nikki Lavakis, which says it's addressed to the select board and the village trustees, and that is admitted. At the end of Exhibit K, there is an employee exit survey, which is admitted. The remainder of Exhibit K is all emails to the listserv, and the board denies admission of these exhibits because they're not reliable. There's no evidence that any of these went to the Board of Trustees, and also they are not relevant. The board excludes exhibits R and T also, in that they were submitted out of time. They were not submitted by the close of business on Friday, the 27th, whereas exhibits P, Q, and S in that group were submitted a year ago, so the submission of those was an administrative cleanup. So everything is accepted except for R and T are excluded in their entirety, and K, the employee exit survey and the initial email in there is admitted. Quick housekeeping, I think we're going to go till 12:30 today and then take a break for lunch.
Can I just ask a clarification? I
Yes.
wasn't sure. So are you saying that there are two portions of Exhibit K that are admissible?
Yes.
Okay, and that's the employee ones
The employee exit survey, which is at the very end of Exhibit K,
and the first part by
appears to be Nikki Lavakis, an email apparently sent on April 1st of 2025.
Okay, so those are in.
Correct.
And so one of the letters is in and one is out. Q is in and R is out.
R and T are out.
Right. R and
P,
T.
Q, and S.
T
are
is the
news
media.
article.
That's out.
Correct.
But Q is one letter, November 26th, from Attorney Bloomer to Attorney Vassallo, and R is the response. So the one is in and one is out. Q is in and R is out.
Correct.
And why is that?
Because they were submitted out of time. They were not submitted at the last hearing, and they were not submitted by the close of business, so it deprived the manager and the manager's council of the opportunity to look at those as per the deadline that we set upon your request.
But why is one in and one out?
Because one of them was actually included in the package of evidence last time around, and one was not.
Oh, okay. Okay.
Thank you. Okay, with that, it is your case.
Thank you. I'd like to call Manager Duffy to the stand, please. And I'm sorry, did you state the grounds for Exhibit T? Is it just that it wasn't provided in time? Is that the
Correct.
no timeliness?
Correct. I mean, I would also add, that was the primary ground. It also was not reliable.
Well, so I can't question about it to prove reliability.
Correct. I mean, it's also not relevant is the other piece.
Okay. Someone swear?
Yeah. Would you raise your right hand, please? Do you solemnly swear that the testimony you are about to give in this cause will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
And just to clarify, there's nothing we can do about the fact that it keeps, people are unable to hear this hearing.
We are doing the best that we can with the circumstances that we have. We have a hardwired line, but apparently the construction next door is causing it to break up. So if people want to come in, this is an open proceeding and they are welcome to come in. And hopefully the Zoom will remain up as much as possible, but that's as much as we can do in the circumstances.
Okay. There's no chance of maybe moving it to someplace where we can get Zoom access?
There is no chance of doing that. I mean, if people could try to call in to see if that helps, but otherwise, I don't think there's any other arrangements we can make.
Okay.
Thank you.
Did you swear him in? I'm sorry, I missed
Yes,
it.
I did.
Okay.
He's sworn in.
Thank you.
Can you speak louder, please?
I can, thank you. I can speak very loud. All right. All right. Good morning.
Good morning.
I hope it's still morning. All right. We're here today because you once again are wanting to demote Chief Swanson, correct?
I believe the evidence that's been presented is to remove him from office, correct?
You want to demote him,
Yes.
okay? And you believe you are legally entitled to demote Chief Swanson, correct?
I'm just going to object to the extent the question calls for expertise.
Yeah, I mean, he's not an attorney, so I think he can ask within the scope of his knowledge and his expertise, but that's the extent of it.
Within the scope of your knowledge and expertise, you believe that you are entitled to demote Chief Swanson, correct?
Yes.
Okay. And you're taking that position despite the fact that he has a contract in place as the chief of police of Woodstock, correct?
Yes.
And you agree that Chief Swanson's contract says nothing about an ability to demote him, correct?
I don't have the contract in front of me, but that's my understanding.
That's your understanding. You agree it says nothing about demotion as an option.
I believe that's correct.
Okay. And you have a contract in place as well, correct?
Yes.
And do you believe that you can be demoted if the trustees decide that your job performance does not meet their standards?
I'm going to object to the relevance of this question.
Yeah, how is Mr. Duffy's contract relevant to Mr. Swanson's contract?
It's relevant because it applies different standards of conduct and different standards of, he's applying a whole different analysis to himself rather than to Chief Swanson. They both have contracts. They both have contracts that do not say anything about demotion. And yet he's claiming that Chief Swanson can be demoted. I think I'm entitled to know if he believes he can be demoted as well.
Go ahead.
I was going to say that's entirely irrelevant. There are different legal standards that apply to town managers and police chiefs. The contract that Mr. Swanson signed says that he can be terminated or removed.
Excuse me, no one can hear anything.
I'm sorry, I'll do my best to keep
And I
my
have hearing aids in, but it's impossible to understand what you're saying, and this is a public hearing.
This is a public hearing, and you are entitled to attend, but if you cannot hear, that is not something that is within our control. So the people who are participating in this can participate, but if you can't hear, that there's nothing we can do about that.
We have
Posted
raised
under the
your voices
ADA.
to make an effort to be heard.
Yeah, you can speak up.
No one is speaking up loud enough to hear anything.
And they are not required to.
Oh,
I fail to see how Manager Duffy's contract is relevant to Mr. Swanson's contract. I think you are entitled to ask anything you wish about Mr. Swanson's contract, but I fail to see how Mr. Duffy's contract is relevant to the case at all.
Well, first of all, the standards are not different for removal of a town manager. The statutes are not considerably different. The same standards of just cause or cause apply. And he is taking one position for Chief Swanson. Again, this is about bias, it's about standards, and it's about applying different ones. He's telling me, and you just heard, that he believes that he's illegally entitled to demote Chief Swanson despite his contract. And yet I'd offer proof. Apparently, he doesn't believe he's.
So if you wish to ask a general question about the standards, that is fair game, absolutely. But his contract is not.
Has his contract been excluded from evidence? Has that not been admitted?
It has been admitted, but it's still, I don't see how this line of questioning is relevant to Mr. Swanson's contract.
Okay. Do you believe that employees with contracts can be demoted even to a different position than they've been hired for?
I'm just gonna, same objection.
I'll allow the question.
Can you repeat the question, please?
Can the reporter read it back, please?
Question, do you believe that employees with contracts can be demoted to a different position than they've been hired for?
I believe they can be removed from their contract based on their actions, and if demotion's an option, then yes.
So is your answer yes, that they can be demoted from the position they were hired to perform, even if the contract is silent about demotion?
I just gave you my answer.
Is your answer yes?
I believe I gave you my answer.
Well, is your answer yes? That's what I'm asking you.
Yes.
Okay. And do you also believe that employees can be provided, when they are demoted, that their salary can be reduced to a lower standard to their new position if they are demoted, despite the contract provisions?
I believe on the scenario we're talking about, we're saying that they've been removed from their contract and to a new position, and potentially there is a union contract that would label what their salary would be.
I'm not discussing union contracts or anything. I'm just asking you if you believe that when an employee can be demoted to, which you've already said yes, to a different position. And my next question is, when that employee is demoted to this new position, you can then reduce their salary to something other than what their contracted amount was.
Yes.
Okay. And I assume that this is not going to be allowed, but let me just get it on the record and we'll see. So do you believe it's proper for the village to reduce your contracted salary if you are assigned to a different position?
Objection, the terms of Mr. Duffy's contract, his legal agreement is entirely irrelevant.
Sustain.
Okay. Now, you agree that progressive discipline provisions were, in fact, incorporated into Chief Swanson's signed employment agreement when he signed it?
The personnel policy that was in place at that time, I believe had progressive discipline, yes.
Okay. And then, over a year later, that progressive discipline provision in that original personnel policy was, well, let me just talk about the original personnel policy. That was in place for most of the time that Chief Swanson was operating as a chief of police, correct?
I believe it was modified and voted on August 2024, so he would have been chief for about 13 months at a time.
Well, is the answer yes? Most of the time he was chief, right?
Yes.
Okay. And in that original progressive disciplinary policy, it had provisions that you had to first go through verbal warning, then written warning, before more serious discipline like suspension and termination could take place, right?
I just want to object that these questions, this line of questioning has been fully covered at the first hearing and that it's cumulative.
Point taken, but I'll allow the question.
Understood.
Again, I don't have the personnel policy in front of me, but I believe there was a line after that that allowed you to skip over any progressive discipline if you felt that it was needed.
And that would be for egregious activities, right?
I don't have the policy in front of me. I can't quote
Okay,
it.
well, we can look at the policy. It's been put into evidence already in the original thing. So since you are having difficulty remembering it, we can refer to it.
May I approach to present them?
Yes.
Okay. Let's look at page. Okay, It starts on page 839. And the actual thing I'm referring to is on page 842. Could you turn to that?
I'm there.
So you didn't remember what the original policy said?
I did not have it memorized now.
Okay.
It's also an outdated policy, so it's not something I need to be on top of all the time.
Pardon me?
It's also an outdated policy, so I don't need to have it refreshed in my mind all the time.
Oh, okay, since last August, you said, right?
I believe it was August 2024 where the new policy was voted on by the boards.
Oh, August 24, okay. Okay, so let's look at the section 1. The one you're referring to, it says, in its sole discretion, deviation from the process is warranted for egregious or serious conduct. Is that right?
Correct.
Section 1, do you see that?
Yes.
Do you agree that I read that correctly?
Yes.
Okay, does that refresh your memory that in order to deviate from the warnings, that it would have to be egregious or serious conduct?
In the sole discretion of the village, yes.
But there's discretion to decide what's egregious and serious, right?
Correct.
Have you decided that any act of Chief Swanson was egregious?
I'm just going to object. This is not the policy that currently applies, and to the extent, I just renew my objection on cumulative. This has already been exactly asked and answered in the first hearing that went.
On that point, I'd like to just ask, why are we asking questions about a policy that I don't think was at issue in the discipline before?
It's an issue. Why would it be an issue? This was the policy that was in place when Chief Swanson was alleged to have committed these acts. Why wouldn't it be in place? You can't retroactively say, I mean, I guess the appellate court can decide, but retroactively deciding that just because a new policy was in place, this is the one that he signed his contract for.
The policy was superseded. Employers have the right to change their policies. It was properly voted on and implemented. And at the time of the Loudermill letters, which is the scope of this hearing, that the policy, which is currently the subject of the questioning, was superseded by another policy. That is the policy that applies. That's my position.
It's a legal argument, but it's not binding, and the appellate court doesn't have to accept that.
But if the policy was not in place and it's not the policy that he was disciplined under, I fail to understand how it's relevant.
Because we are arguing that these alleged actions occurred during the time that progressive discipline was in place. To retroactively go back and say it doesn't apply. Other things apply from that period. Other parts of that policy apply to Chief Swanson, but this one doesn't.
Okay, we will allow the line of questioning.
Can you repeat where we were? I don't think anyone remembers the last question.
Last question, have you decided that any act of Chief Swanson was egregious?
The total amount of actions combined, I do.
I'm not talking about the total actions. Did you hear my question? I said, did you determine that any one act was egregious?
Yes.
And what was that?
Sharing evidence with the residents of an ongoing investigation. Leaving work without signing in or without signing off. Could also be wage fraud. Being unresponsive to your employees while you're working, especially when you're a working chief and have to respond to calls. Yes.
Are you
Parliament. I will not tolerate shaking of heads, smiling, or responding to the witness in any way. It is disruptive. We will not allow it. This is a warning. If it continues, I will ask you to leave. Thank you. You may proceed.
Can you read the question back? Sorry. Oh, there's a question, okay. All right. I was about to make a question, okay. I just heard that answer you last gave, and it's the first time I've ever heard the word fraud mentioned in response, in connection with Chief Swanson. Are you now, for the first time ever, accusing Chief Swanson of some type of fraud?
I said potential wage fraud.
What does that mean? You're not claiming he did commit any fraud?
If you are getting paid to work and you're 25 minutes away getting a haircut, you're not working for that wage. So I said potential.
What does that even mean? Did you investigate him for fraud?
In his affidavit, he said that he at least twice, got his haircut in White River during working hours.
Did you investigate him for fraud?
No, not yet.
Not yet? Are
Well,
you
not,
planning to?
I got the affidavit on Friday, I haven't looked into it.
Oh, so you're planning to investigate him for fraud?
I'm not saying that.
Okay. And so if any of your employees get a haircut while they're on duty, they're potentially committing fraud?
If a employee is unable to do their work while they're getting paid, that would be an issue I'd look into.
That's not what I asked you, Manager Duffy. Could you please answer the question? I asked you if any of your employees got a haircut while on duty, are they potentially committing fraud?
I think it depends on the situation.
Pardon me?
I think it depends on the situation.
It depends on the situation.
Correct.
So what would it depend on?
Are they able to do their job at the time?
So an employee can do something personal, like get a haircut, as long as they're able to respond to their job?
Potentially.
And how do you know that Chief Swanson wasn't in that same position?
He was out of Woodstock, at least 20 minutes away from Woodstock. If there was a call for service, he would not be able to respond within 30 to 40 minutes.
But you don't know that he was on duty, that he was the duty officer that was assigned to respond to calls, do you?
I don't.
Okay, so it's okay for somebody to get a haircut in Woodstock, but not 20 minutes away?
If they're on duty, I would say no.
Somebody on duty cannot get a haircut in Woodstock,
No, I said if someone is on duty outside of Woodstock.
but somebody on duty in Woodstock can get a haircut
I
and
already
not
answered-
be exposed to potential fraud.
I already answered that question.
Is that yes?
I already answered that question.
Well, could you answer it? I didn't understand.
I believe the clerk could read it back for you if you want.
No, the clerk is not going to read it back. I'm asking you to answer it.
Answer the question, please.
So what's the question again?
The question is that an employee can get a haircut in Woodstock and be on duty and not be subjected to potential fraud, in your opinion.
My answer is that may not be potential wage fraud.
But it may be.
Sure.
Okay. And did you ever investigate whether any of your other employees were, in fact, getting haircuts while on duty?
I don't say that's relevant to Chief Swanson.
I asked you, did you ever investigate whether any of your other employees got haircuts while on duty?
Yes.
And did you find that they had?
Yes.
How many?
One.
One employee you found, how many times?
To my knowledge, just once.
Just once? Was that employee disciplined?
They were counseled.
Counseled? Was any verbal warning or written warning or anything like that given?
No.
So you decided that that one employee that was getting a haircut on duty in Woodstock was not subject to any disciplinary procedure?
Correct.
Did you ask if it had happened more than once?
I do not recall.
So you didn't investigate this, you just accepted that this might have been just once?
I investigated that incident.
So you didn't ask about any other incidents?
I do not recall if I did or not.
Did you ask any other employees whether they had done the same or seen anyone else do the same?
I did not ask all my employees now.
Okay, did you, you said you provided counseling. What was the counseling?
That even though this person was in the village with their radio, able to respond to a call if needed, it was not appropriate to be getting a haircut while on duty.
And this was Sergeant O'Keefe?
Yes.
And this was all verbal, nothing in writing?
Correct.
Okay, so you were part of the new, you were part of the making recommendations for changing the progressive policy, right, the progressive disciplinary policy.
It was led by another employee at the time, and I was supervising it.
But you made some recommendations for changes and then it was approved, correct?
I'm just gonna object, this is entirely cumulative with the first hearing.
Yes, I agree. I will allow this line of question, but it is getting to be cumulative. We did cover this exact territory in the first hearing.
There were parts of it I did not cover. Can you just, can I have some leeway here in terms of?
Yes, that's what I'm saying. I'll give you some leeway, but if,
Okay.
I don't think we should spend the whole day on it.
And we're not spending the whole day. So my question was, you made recommendations for changes to the progressive disciplinary policy, and then the select board and the trustees approved it, right?
I made recommendations to the personnel policy, correct?
Okay, and then it was approved.
Correct.
And I don't think you answered this in the first one, so let me ask you. You agree that taking out a progressive disciplinary clause is not in the best interest of your employees, correct?
I think that was asked.
I will allow the question.
I think the goal of the personnel policy when we updated it was to make it more employee friendly, and we encourage employees to have a say in that policy, and many of them did, including Joe Swanson.
Manager Duffy, you're not answering my question. I'm asking you, do you agree that taking out a progressive disciplinary clause in the personnel policy is not in the best interest of employees?
I agree. It's my job to do what's in the best interest of the municipality.
Pardon me?
It's my job to do what's best for the municipality.
Right.
Yeah.
So you agree it's not in the best interest of the employees?
Yes.
Okay. Now, the complaints that you received about Chief Swanson in October 2024 dated back to that time that the progressive policy was in place, correct?
Probably, yes.
So if you had heard the same complaints about Chief Swanson, the exact same complaints you heard in October of 2024, if you had heard those in July, you would have had to provide the progressive discipline that the personnel policy in effect at that time required, correct?
No.
Pardon me?
No.
You would not.
The policy states town, village, in its sole discretion, can deviate from the process if warranted for egregious or serious conduct.
So your testimony is that if you had heard in July, or if you had gone through, done a deep dive into the emails and saw that there were some communications that he claimed were for attorney consultation, you would have terminated him immediately in July of 2024?
Regardless of when I received the information, I would have made the same decision.
You would have terminated him immediately, or removed him from his position immediately in July if you had discovered that he had shared some emails for legal consultation?
All the information that I received, I would have made the same decision.
And you know from what you've seen today that in terms of the exhibits, that you know that former Chief Blish has indicated he does not believe any violations of policy occurred with that sharing, correct?
I read his affidavit, yes.
Do you disagree with former Chief Blish?
I do.
So Blish's former Chief Blish's opinion would have no impact on your decision.
In this scenario, no.
Okay, and you've also seen the expert opinion that this did not violate any policies, that his sharing for legal consultation did not violate any policies. You also would not change your opinion based on that.
I'm sorry, what experts?
Richard Mello, the affidavit.
Correct.
Okay, so you would disregard you would disregard two chief polices, two former chief of polices, to substitute your own judgment as to whether that violated a policy and required termination.
I'm going to object that misstates the testimony.
I don't recall the testimony precisely. How does it misstate it?
The questions were about whether the affidavit submitted in this proceeding on Friday afternoon, whether he agrees with them or not. That's not the same as disregarding and substituting his own judgment.
He said he would make the same decision. That's his judgment.
And the question's argumentative too, I guess I'll also say.
Yeah, I'll allow the question.
Could the
My
question be read back
question-
to me, sorry?
Yeah. That's what I'm sure.
Question, so you would disregard you would disregard two chief of police, two former chief of police to substitute your own judgment as to whether that violated the policy and required termination.
In this scenario, yes.
Okay. And is it your testimony if you had, in addition to the sharing of evidence that you believe required immediate termination for egregious behavior, was there anything else that fell into that category for you?
Yes, I believe I've already stated that.
So you think the absences that you heard about were cause for immediate termination?
I think those actions were egregious, and I think the combined total of it would move for action, yes.
Pardon me?
I think the combined totality of all the actions were egregious enough to move towards removal from office.
We're not talking about the combined. I'm asking you for specifics in terms of which specific actions you believed rose to the level of egregious behavior under the old personnel policy that required immediate termination.
Yes, I think numerous absences would, and not being able to be contacted while you're on duty and potentially being paid for it would, yes.
So that would not be something that would require a verbal or written warning that would immediately go to termination.
Yes.
Okay. So the sharing of the evidence, the absences for immediate termination, anything else that I've missed?
Not that I can recall, no.
Okay. So you would have decided under the old policy back in July that there was no chance for Chief Swanson's rehabilitation based on the things you just described.
These are hypotheticals, and they're making assumptions based on facts that are not in evidence.
I do agree with you, but I will give some latitude on this, at least for a little while.
So I can read back the question?
Questions, you would have decided under the old policy back in July that there was no chance for Chief Swanson's rehabilitation based on the things you've just described.
Yes.
And you, based on that, I also assume that the answer is yes, that you did not believe that the principles of fairness warranted notice or any warnings for Chief Swanson around the things you've just discussed.
So you read that question?
Would you read it back, please?
Questioning you based on that, I also assume that the answer is yes, that you did not believe that the principles of fairness warranted notice or any warnings for Chief Swanson around the things you just discussed.
I would take issue with the word fairness being in there.
Wait, does fairness not apply here?
I think it's my job to do what's best for the municipality, and in this scenario, I've stated what I would have done.
I guess I'm not understanding. Are you saying that it's perfectly okay to be unfair in your treatment of Chief Swanson?
I'm not saying unfair or fair. I'm not sure what you mean by fair in this scenario.
What I asked you is if you believed the principles of fairness warranted notice and warnings for Chief Swanson. That was the question. And I believe you're saying that principles of fairness don't apply, but if that's not your words, I don't want to put them in your mouth.
I'm sorry, I'm just confused by what you mean by fairness in this
I can
ability.
see why you're confused. I mean, the concept does appear to be confusing to you. But
You're
I-
arguing with the witness. You can ask a question, but you can't argue with the witness.
Well, he's telling me that he doesn't understand it. I don't know what to say here. What is it that you don't understand? So I can try to rephrase my question.
It's Attorney Frost's job to ask questions and his job to answer. Perhaps she could try another question.
No, he just told me he didn't understand the question. I want to know what he doesn't understand.
Perhaps you could rephrase your question.
All right. All right, let's try this. I'll break it down. Do you believe that principles of fairness apply to your treatment of Chief Swanson in general?
So are you saying that, are you asking me if I treat Chief Swanson fairly?
Do you believe that principles of fairness, and I was I was explicitly talking about notice and warnings for Chief Swanson, but I've asked you, since you didn't seem to understand that, I'm breaking it down. Do you believe that principles of fairness apply in general to Chief Swanson?
Yes.
Okay, so my next question is, do you believe that those principles of fairness warranted notice and warnings to Chief Swanson about what he allegedly was doing wrong?
No.
Okay. But you yourself believe that you are entitled to fair warning before being terminated for cause if you're accused of failing to perform your duties or are negligent in the performance of your duties. Is that right?
How is that relevant to Mr. Swanson's contract?
It's relevant because I keep saying this is disparate treatment. He's applying different standards to himself. He's just told me no fairness applies to Chief Swanson, but he wants to ensure that he's treated fairly. That you're telling me that's not relevant?
Well, the manager does not supervise himself. So that's issue number one. The Board of Trustees does. Or the Select Board. Second, I suppose if you wanted to ask about another employee who the manager supervises, that would be at least closer to fair game, but generally speaking, the issue here is about Mr. Swanson's contract and what actions were appropriate under Mr. Swanson's contract.
But we're also talking about bias, and we're also talking about different treatment between the manager and Chief Swanson. So that was, if you wanted to prevent the question, that's fine, I'll move on. Are you telling me I cannot ask that?
Simply asking for relevant questions.
Am I prohibited from asking about that particular question?
Yes, because it was not relevant.
Okay. And so your testimony, Manager Duffy, is that Chief Swanson should be given 0 days to correct any performance issues you allege, correct?
Yes, I think in the role he's taking on, there's some expectations that he should need to follow.
You've also claimed under oath, haven't you, that Chief Swanson is not, there's no just cause language in his contract, right?
I don't have the testimony.
Okay, let
Right,
me,
yeah, but-
let me show you what I'm talking about. I've got copies. Okay. May I approach?
Yes.
Okay. I'm going to show you an affidavit that you made, and we're going to look, I can tell you your specific here. We're going to look at, okay, affidavit number 5 here. Find the exact spot. Thought I had it highlighted, but it might take me a second here. Let's find it. Ah, here it is. I just highlighted on this copy. All right, this is an affidavit that you signed in September, on September 22nd, 2025, under oath, correct?
Yes.
And in that affidavit, paragraph 5, counsel, you say that you're talking about the employment agreement between Chief Swanson and the village, correct?
Mm-hmm.
You say the agreement document does not require just cause, but rather requires cause. You're claiming it doesn't require just cause, right?
I'm claiming the agreement does not have that in there.
Right. But actually, let's look at the actual contract. And I think we can look at it right here together with, on that. Okay. Let me find the right one. Page 642. Oh, that's mine. I'm sorry, 642. Okay, section 13. Do you see that?
Yep.
Okay, section 13. I'm sorry, let me go over there so I can point it out to you. Okay, section 13, number 2. The first sentence, let's look at that. After the first year of employee's employment, employer may terminate employee's employment for just cause. That exact phrase is in there, isn't it?
It is.
So you testified, you wrote under oath that it didn't, and it actually does. Is that right?
What page are we looking at? In the
642.
643.
It's the hearing transcript from last time, and it's got the exhibits from last time, which includes the employment contract.
Thank you.
Okay, we can move on. You can close that. You can close that. I'm done with that question.
I can keep it open, can I?
No, I'm closed. It's fine.
Okay.
Okay. And your position has been that any transgression by Chief Swanson does not have to meet the just cause level for termination from his position as chief, correct?
It is a legal question, but he is the manager, so he has some expertise and knowledge about it. So I'll allow it.
Can you repeat the question, please?
Oh, sorry.
Question, and your position has been that any transgression by Chief Swanson does not have to meet the just cause level of termination from his position as chief, correct?
Correct. The contract also says for cause as well.
Under what?
The contract also states for cause as well.
Well, that's not what I asked. Your position has been that just cause, and you said it under oath, that just cause was not a factor in his contract, right?
Correct?
Okay. Okay, let's talk about the no confidence vote. You said that that had a massive impact on how you viewed things around Chief Swanson, correct?
This is one of the many factors.
You used the word massive impact, didn't you, in your previous testimony?
I'd have to look at it to,
Do you want to look at it, or are
Sure.
you denying it, or?
I'm not denying it, I'd still look at it. Do you know
Well,
what
let
page
me
it's
just
on?
ask, to expedite things, did the no confidence vote have a massive impact on how you viewed things going forward with Chief Swanson?
It was one of the many factors I considered, but it had an impact,
All
yes.
right, well, if you agree-
Witness is still answering the question.
I'm sorry, go ahead.
It had an impact, yes.
Did it have a massive impact?
If that's a word I used in the past, then yes.
Well, let's look at it, since you don't
Sure.
seem to remember. It's page 343.
Yes.
Line 23. Massive impact, right? It had a massive impact, on how I view things going forward. You're talking about the no confidence vote,
Yep.
correct?
Can I just read it, please?
Yeah, of course.
Thank you. Yes, I said that.
Okay, you can close it. And you had been claiming that all of Chief Swanson's employees took a vote of no confidence. That was your understanding, that all of the people who worked underneath him had voted no confidence, correct?
It was my understanding that was a unanimous vote.
You were under the impression that all of his employees had voted to no confidence, correct? All the people who worked underneath him.
I was under the assumption that was a unanimous vote.
Just what I asked you. I asked you if you I believe that all of the people who worked underneath him had voted no confidence.
I had no reason not to believe that.
But that is what you believed.
Yes.
Okay. And you didn't do any investigation into whether that was in fact true, did you?
I don't believe management can compel or coerce union members to talk about union business.
Pardon me?
I don't believe management can compel or coerce union members to talk about union business.
My question was, because you believe that, you did not conduct any investigation into how the vote was taken, whether it was unanimous, that type of thing.
I don't believe as management I'm able to.
And so you did not, because of
Correct.
that belief. And we've submitted Exhibit P. There were two versions of the, I don't need you to look at it. I'm just going to ask you a question.
Yeah.
There were two versions of that no confidence letter that were submitted to you, correct?
Correct.
One said that a formal vote was taken, the other said that a unanimous vote was taken.
Correct.
And you didn't ask any questions because you didn't think you had the ability to ask any questions about what that really meant, right?
No, I received one letter the one day and the next one the next day, I believe.
And that didn't cause you to ask any questions because you thought you just had to accept what was provided to you.
Correct.
And you heard at the hearing during Sergeant O'Keefe's testimony that he in fact did not vote no confidence, right?
I believe he abstained.
Right. So you actually knew this before the hearing, didn't you?
That Chief O'Keefe had abstained.
Yeah.
I do not recall.
So you may have known ahead of time.
I may have known.
And if you had known ahead of time, then you would have known that the vote was not in fact unanimous, that not all of the people who worked underneath Chief Swanson had in fact voted.
I believe O'Keefe abstained because he was the acting chief at the time and did not feel it was appropriate to take part in that vote.
Right, so when you said all of the people who worked underneath Chief Swanson had voted no confidence, you knew that wasn't correct, that Sergeant O'Keefe had not in fact voted, right?
Like I said, I don't recall if I knew at the time or not.
Okay. But you certainly knew after the hearing that Sergeant O'Keefe did not vote no confidence.
Correct.
And yet you still maintained that all of the people who worked underneath Chief Swanson had voted no confidence in him, right?
I believe I consider it still unanimous, yes.
And did Sergeant O'Keefe tell you that he abstained from voting because he was interim chief?
I believe so, yes.
And you believe you had that knowledge at some point before the hearing?
I do not recall.
Did he tell you that the reason that he didn't vote was because he was interim chief and that he might be appointed chief after the hearing and he didn't want the appearance of any conflict?
I don't believe so, no. And just for clarification, he was acting chief, I believe, when the vote of no confidence happened?
And you had planned, in fact, to appoint Sergeant O'Keefe after removing Chief Swanson, correct? You planned to appoint Sergeant O'Keefe as the chief of police of Woodstock.
After the trustees' original decision to
Yes.
remove Joe Swanson from chief position, it was my thought that O'Keefe would be the next chief.
Right. And that thought didn't just occur to you immediately after the decision. You were thinking of putting him in that position before you were assuming that he would be in that position as you would appoint him chief if the board demoted Chief Swanson, right?
No, I wasn't going to assume what was going to happen with the trustees.
Pardon me?
No, I was not going to assume what would happen with the trustees in
Okay.
the decision.
So you didn't know one way or the other whether you would have to appoint a new chief, but if you needed to appoint a new chief, Sergeant O'Keefe was your guy, right?
I think what Sergeant O'Keefe had did from October 2024 up through April 17th was very impressive.
Okay, so you had identified him as the person to be chief in the event that Chief Swanson was removed.
I identified him as someone who could be chief.
Pardon me?
I identified him as someone who could be chief.
In fact, you had discussions with him about that, didn't you?
I don't believe so, no.
Well, immediately after the decision, you were trying to install Sergeant O'Keefe as in Chief Swanson's chair, weren't you?
I made him interim after the decision.
You also opposed a motion for preliminary injunction that and wanted to appoint him as chief, right?
Object to that. Positions of counsel in litigation outside of this context is not relevant to this hearing today, and there's no way he can answer the question without getting into attorney-client privilege, so I just object on that basis.
Sustained?
Sustained?
Yeah, I don't see really how that's relevant. I mean,
You don't think this is relevant to the credibility of the testimony by Sergeant O'Keefe, who's in line for becoming chief, or the bias against Chief Swanson, or just?
Give me your question one more time, please.
Pardon me?
Give the witness your question one more time.
Will you wait. Read it.
Question, you also opposed a motion for preliminary injunction that, and wanted to appoint him as chief, right?
Yeah.
Go ahead and answer the question.
We opposed the injunction, yes. We had been short-staffed for, I think, 8 months at that point, and we had to move forward. And it would have been my intention at the time to make O'Keefe chief.
Okay. And apparently, it sounds like from what we heard earlier today, you've done some investigation since you received the affidavits of Carolyn Lord and Lisa Linton about what the vote, how the vote took place and who voted what. Is that what you're saying?
I asked one clarifying question.
So you were able to ask a clarifying the question about concerted union activity when you found some opposing statement?
No, I asked if the vote was unanimous.
So you were able to ask that only after you found out that people were claiming that it wasn't enough?
I think my earlier statement said I can't compel a course, and so I asked a question that they could have denied or chose not to answer.
Those are all the same questions you could have asked back in November of 2024 then, right?
I could have in November asked if the vote was unanimous. Yes, I could have done that.
So the first time you thought to ask that was when you saw an affidavit from someone claiming she did not, Carolyn Lord did not vote.
Correct, because it was the first time in 16 months I heard something different.
And you did not find any information to indicate that Carolyn Lord had in fact voted, correct?
I believe her affidavit says that she did not vote, yes.
You found nothing contrary to that.
Correct.
And if you look at Lisa Linton's affidavit, she says there was no meeting. That would not be inconsistent with what you found out when you decided to ask about the vote, correct?
Correct.
She doesn't say she didn't vote. She said she received confusing and strange emails that she found upsetting. She doesn't say she didn't vote. She's saying that she felt pressured to vote by management, correct? Or by supervisors in her last paragraph.
What page in the transcript around, if you're referring to that?
Hold on. It would be Carolyn Lord, not Carolyn Lord, Lisa Linton. It's under number 7, tab number 7. Oh, no, actually, tab number 8, I'm sorry. Tab number 8. And we're looking at the last paragraph, number 10.
And just as a general rule, could you point out to us where we are? 'Cause
I
we're
will, I'm
hopping
sorry.
around here.
So, Manager Duffy, you saw that part where it says that Lisa did not speak up further at the time regarding her concerns because she feared, and still fears, and she's still an employee, right? Retaliation from some of her supervisors, correct?
Hold on. You were talking about tab 8. This is Lisa Linton's affidavit you're
That's what
referring
we're talking about.
to. You just said tab 7, so.
I'm sorry, tab 8.
I mean, that is what she's said, yes.
Okay. And she never says in her affidavit that she did not vote. She's just telling you in this affidavit what the circumstances were, correct?
Yeah, I don't think she's telling me, but I think she's telling the court, yes.
Okay. And did you inquire further about when you asked the question recently to someone about the vote? Did you inquire where this took place, what time of day it took place, how it took place?
No.
Okay. Did you ask?
Just trying to understand your questions. Are you asking about what time the affidavit was signed, or what time the vote was, or something else? Just
I'm
because we're a
asking
little bit
about the
confused.
circumstances about the vote. I heard that Manager Duffy asked one question of one employee after he saw these affidavits. Am I correct about that?
Yes.
Okay. And what I'm asking is, in the context of that, did you ask anything about when the vote, where the vote, when the vote was taken, who else was there, that type of thing?
No.
Okay. And did you ask about the dispatchers or the police?
I asked about the dispatchers.
Okay. So you didn't do any inquiry about the police?
No, but I had no evidence that someone didn't vote.
So you would only inquire if you saw, if anyone came forward and said that they had not voted?
I had no reason to believe that anyone did.
Okay. Is this a good stopping point? You think you said you
If-
wanted to?
If that works for you, it is just.
It
about-
is. I'm
okay.
at the end of the section.
Okay, okay. You're under cross-examination, you're not supposed to speak to your counsel about questions that you're being subject to,
Okay.
so that's the instruction. So we'll come back at 1:30.
Okay.
Is that?